Hello and welcome to our webinar GDPR 1 Year On. In this course, we will cover GDPR refresher, dealing with data breaches and how to engage with the ICO, employee surveillance, subject access requests, and Brexit and data transfers. Just to recap why employment data is such a headache in terms of GDPR. The implications for data relating to employees are particularly significant for the following reasons. Businesses are likely to process significantly more data in relation to employees than in other contexts. Data processed on office workers might include, for example, CCTV film on their arrival at work, lift or floor access information, data on computer logon, and data on websites visited, phone calls made, and emails sent or received. Much employment data is likely to be unstructured. This creates particular challenges. The text of an email may contain personal data about the sender, the recipient, or a third party. Some of that data may be sensitive personal data, or even sensitive personal data about a child. For example, "Sorry, can't make it to the meeting, my daughter has chickenpox." Although the employer is a data controller, it exercises little or no control over unstructured data such as this. Let's remind ourselves of some of the key terms under the Data Protection Act. What is processing? Processing is any adjective you can use to describe doing something with data. Processing of personal data includes, for example, the collection, storage, use, alteration, disclosure, and destruction of information. For processing to be lawful under the GDPR, you need to identify a legal basis before you can process personal data. There are 6 legal bases available for processing personal data, but we have identified 3 that are most likely to apply in the employment context. The first is that processing is necessary for the performance of a contract with a data subject or to take steps to enter into a contract. Where employers process employee data to fulfill fundamental contractual obligations, such as paying employees or monitoring employee attendance, for example, they will be able to rely on the ground that processing is necessary for the performance of a contract. The second is that processing is necessary for compliance with a legal obligation. For example, where employers process employee data for tax or reporting purposes, or to provide statutory employment entitlements such as annual leave, maternity pay, or sick pay, they will be able to rely on the ground that processing is necessary to comply with a legal obligation. The third is that it is necessary for the purposes of legitimate interests pursued by the controller or a third party, except where such interests are overridden by the interests, rights, or freedoms of the data subject. For example, employers could assert that processing employee performance data is necessary to improve workforce performance, or that processing employee data during a workplace investigation is necessary to respond to an employment dispute. However, note that with legitimate interests, the employee has the right to object to processing. The right to object could cause significant delay and disruption in the context of disciplinary or grievance procedures, redundancies, terminations of employment, or business sales. Once you have at least one legal basis for processing data, then you have to comply with all of the principles on the screen. So, the data has to be processed lawfully, fairly, and in a transparent manner in relation to individuals, collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. Further processing for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes shall not be considered to be incompatible with the initial purposes. Adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. Accurate and, where necessary, kept up to date. Every reasonable step must be taken to ensure that personal data that are inaccurate, having regard to the purposes for which they are processed, are erased or rectified without delay. Kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. Personal data may be stored for longer periods insofar as the personal data will be processed solely for archiving purposes in the public interest, scientific or historical research purposes or statistical purposes, subject to implementation of the appropriate technical and organisational measures required by the GDPR in order to safeguard the rights and freedoms of individuals, and processed in a manner that ensures appropriate security of the personal data, including protection against unauthorised or unlawful processing and against accidental loss, destruction or damage, using appropriate technical or organisational measures. All data controllers, that is, employers, have to register with the ICO and pay a registration fee. There are 3 tiers of fee ranging from £40 and £2,900, depending on size and turnover. Tier 1 is micro-organisations, where there's a maximum turnover of £632,000 for the financial year or no more than 10 members of staff. The fee for Tier 1 is £40. Tier 2 is small and medium organisations, where there's a maximum turnover of £36 million for the financial year or no more than 250 members of staff. The fee for Tier 2 is £60. Tier 3 is for large organisations. Where they do not meet the criteria for Tier 1 or 2, they have to pay the Tier 3 fee of £2,900. They regard all controllers as eligible to pay a fee in Tier 3 unless and until they are told otherwise. It is unlawful to process personal data as a data controller if you haven't paid the fee or paid the incorrect fee. The penalty is a £4,350 fine. Employers discovering a personal data breach must notify the ICO promptly and within 72 hours. If the notification is not made within this time, the employer must provide a reasoned justification explaining the delay. The notification requirement does not apply if the breach is unlikely to result in a risk to data subjects, for example, because all the data on a laptop was encrypted. It's therefore very important to make sure that staff are trained to know how to look out for a breach and how to report it up the line. In notifying a breach, an employer must describe what happened and set out the approximate numbers of individuals affected, the likely consequences, and the measures taken or proposed. If there is a high risk to a data subject, he or she must be told. Records must be kept of all data breaches and action taken, including those in respect of which there was no obligation to notify the regulator. Data breaches can occur at any time and are not uncommon. For example, most businesses lose laptops and memory sticks from time to time. Some emails go to the wrong recipient. Although not all such breaches are serious in their impact or need to be notified. The 3-day time frame means that employers will need to have clear policies on how they handle a breach, with defined roles fulfilled by individuals who understand what they are doing. When we talk about surveillance, we talk about many different types of monitoring. For example, email content and traffic, internet use, telephone use, CCTV, social media, for example, checking out someone's Facebook page when they apply for a job, bring your own device to work, monitoring time and attendance, and vehicle tracking. Workplace surveillance involves the processing of personal data. CCTV, for example, is still personal data, as you can identify a living individual. As an employer, you must have a legal basis for processing. Could it be performance of a contract, or does the employer have a legitimate interest? The employer must comply with the principles of processing. For example, one of the principles of processing is for personal data to be collected only for specified, explicit, and legitimate purposes. You have to provide sufficiently detailed information about the method by which it monitors its employees, the information it collects, why the processing takes place, how the information might be processed, who the information may be shared with. Also, the results of monitoring should be limited to few staff who have access to the information obtained through monitoring. Data protection impact assessment has to be carried out on existing and potentially new technologies to ensure the rights and freedoms of data subjects are protected. Proportionality. There is quite often a crossover between protecting and breach of privacy. You need to ensure that the monitoring is proportionate to the aim. For example, is there a need to put CCTV in staff rooms? Do you need to read content of emails, not just to monitor the number of personal emails back and forth? Subject access requests. Monitoring requires the collection of personal data and so is disclosable in subject access requests. A subject access request is the right of an individual to obtain from an employer copies of their personal data. Employers have to generally comply within 1 month. You can no longer charge the £10 fee automatically. Subject access requests are causing employers a headache. A step-by-step guide to subject access requests. Acknowledge the request. Acknowledge receipt of the request and tell the data subject when they can expect to receive a response. Request ID. An employer receiving a request is likely to want to make sure that the request comes from the person who is purporting to make it. If it's a general request, you may have thousands of emails or documents which will take significant time. Ask the person to clarify. Emails between who, what dates, and about what. Timing. Although the basic rule is that requests must be handled without undue delay and in any case within 1 month of the receipt of the request, the employer may extend that period by 2 months where necessary, taking into account the complexity and number of requests. If the employer extends the response period, it must tell the employee within 1 month of receipt of the request and provide reasons. Decide who does what. Who will have overall responsibility for dealing with the request? Do IT need to be involved, particularly if access to mailboxes need to be agreed? Who will have the day-to-day responsibility for searching for and locating the data? Do staff know what they are looking for and are they trained? Finding and retrieving the data. This generally includes electronic search words, people's mailboxes, bring your own device to work. If staff are permitted to hold business data on their personal devices, then technically the staff are acting as agent for data controller, so would need to search these devices. CCTV, we will come back to this later, and handwritten notes. Are these disclosable depends, as there is a definition of filing system under the Data Protection Act. If the data is not stored in a filing system, then potentially it is not disclosable. Analyse the data. Taking emails that contain personal data relating to the employee and analyse them to see whether or not there is also personal data relating to other individuals. That data falls into 2 categories. Personal data which relates to other individuals which does not relate in any way to the employee. This is non-relevant personal data. And personal data which is information about the employee but also information about another individual. You can review information which is not personal data at all. For example, information on financial performance or business expansion plans. Such information falls outside the scope of the subject access request and there is no requirement to disclose it. If the personal data is also information relating to another individual, unless that individual has consented, the employer should consider whether, by redacting information, in particular information that would identify the other individual, it would be possible to provide the employee with at least some of the personal data sought. If so, the employer would then redact that other individual personal data. For example, be careful with hidden cells in Excel. And what about CCTV? The Information Commissioner's Office would expect you to outsource obscuring the images of other people's faces or to get consent. Under the old code, the Data Protection Act differentiates between obscuring people coming and going in a drug rehabilitation centre with a bookshop or privacy intrusion to a third-party individuals is minimal. The GDPR states that measures to protect others should not lead to a refusal to provide any information at all. Prepare a response to the employee with copies of documents and information on the purposes of processing, categories of personal data, recipients or categories of recipient, information on source of personal data, retention periods, existence of data subject rights, existence of automated decision making including profiling, safeguards on transfers outside the EEA, and the right to complain to a supervisory authority. Generally speaking, your privacy notice should cover all of this. If you have a well-drafted privacy notice, you can just include a copy of this with a response which will satisfy the requirement to provide information on these points. The form of response. If requested electronically, supply electronically, otherwise you'll have to supply hard copy. Copy of the personal data. The requirement is to provide a copy of personal data and not a specific document. Although subject access requests are generally free, if a request is manifestly unfounded or excessive, the employer may either charge a reasonable fee, taking into account the administrative costs of providing the information or taking the action requested, or refuse to act on the request. In such circumstances, the employer must be able to demonstrate that the request is indeed manifestly unfounded or excessive. If it decides not to act on the request, it must give reasons and tell the employee that if there is a dispute, he or she may complain to the Information Commissioner or apply to the court. It is not yet clear how manifestly unfounded or excessive should be interpreted. However, it seems reasonable to assume that repetitive requests may be excessive. Manifestly has the sense of obviously or clearly, and what is excessive is context-specific and depends on what is at stake. Except in obvious cases, the employers should not be too cavalier in asserting that requests are unfounded or excessive. The Information Commissioner is likely to look closely at the reasoning. It may be a better and more attractive approach to act on the request to the extent that the employer believes it is reasonable and proportionate, reserving assertions that the request is excessive or unfounded for use if that approach is challenged by the employee. The employer must not delete data to defeat a subject access request. It is an offence for an employer or a person employed by the employer to alter or erase information with the intention of preventing disclosure after a request has been made. Data protection is unlikely to be the foremost in people's minds when considering the impact of Brexit, whether it be soft or hard, or deal or no deal. The UK government has, however, recently issued papers about various topics in a no-deal situation, and one of those entitled Data Protection if There's No Brexit Deal. In the event of a no-deal Brexit, with no agreed arrangements covering data protection, the government is advising organisations to prepare appropriate contracts to ensure any transfer of European Union citizens' personal data to the UK is compliant with privacy laws. The UK faces the prospect of being regarded as a third country when it exits the EU. As a result, the transfer of personal data from organisations within the EU to other organisations in the UK will be subject to strict data transfer rules. EU organisations will have to ensure their transfers to UK are lawful, and that's not going to be as simple as it is now. Thank you for listening. If you have any queries regarding data protection or employment law, please contact us.